for today's discussion. So without further ado, I will turn it over to Stacy to get us started for today. Stacy?
Thanks, Chris, and good afternoon, everyone. This is Stacy Barrow from Proskauer Rose in Boston. Welcome back to our 2015 webinar series. This is the first webinar of our new year, and today's topic is preparing for a DOL audit. We are proud to partner with Percential to offer today's webinar to their friends and clients. And I have to apologize, folks, today. I am working from home. We have close to 3 feet of snow here in my area of Boston. It's been pretty quiet out here, but it looks like the plows are starting to start up. So if there's some background noise, I apologize. And also, Chris will be driving today's presentation. And so let's go on to slide 3. Okay, so today's topic is how to prepare for a Department of Labor audit. We're going to talk about which agencies audit and who do they audit. We'll talk about why and when they audit plans, where and how do they audit, and what do they look for in an audit. Let's go to the next slide. There are a number of agencies with jurisdiction over ERISA plans. You have the Department of Labor, the IRS, HHS, and state attorneys general also have a jurisdiction over ERISA plans as it relates to HIPAA privacy. Today, we are going to talk mostly about Department of Labor audits, as they are the entity that enforces compliance with ERISA through the Employee Benefits Security Administration. So in terms of who is audited, the size and the type of employer is largely irrelevant. We see audits of large employers, small employers, public, private, non-for-profit, all different types, and surprisingly enough, we do see audits of fairly small groups. It doesn't happen all the time, but we've certainly seen audits of groups of under 50 employees in the past. So don't believe the myth that only large plans or only self-insured employers get audited. We definitely see audits of fully insured plans as well. Let's go to the next one. So each year, the DOL does select thousands of ERISA-governed plans for audits. In recent years, we have definitely noticed an increase or an uptick in the DOL audits. IRS has a lot of things on its plate right now. They will be implementing and overseeing the employer mandate and the premium tax credits. We expect that there may be an uptick in audits and IRS audits related to those items over the next few years. We're starting to see more involvement from the IRS in cafeteria plans when they engage in payroll audits. HHS is starting to audit more on the HIPAA side, along with state attorneys general. State AGs also have enforcement authority over HIPAA, and they can sue plan sponsors that have HIPAA violations, and the penalties can be very substantial. And so we're starting to see more. Employers have contact with the state AG. And of course, the cynical view here is that the federal government needs dollars with all of the ACA mandates and premium subsidies and credits going into effect. Let's go to the next slide. So the big question that we always get whenever we talk about audits is, how do plans get selected for an audit? And on the next slide, we answer that question. The answer is it is like lightning. It's random. You don't know when or where it's going to happen. We see them in all areas of the U.S., all parts of the country, all shapes and sizes again. So they're really, we've never been able to identify exactly how a company gets selected for an audit. I mean, certainly complaints, participant complaints to the DOL could result in action from the DOL, but other than that, there's really no guidance as to how a company might become selected for an audit. So again, the audit plans all over the country. In terms of how the process works, typically it starts off with a letter. And the letter has a fairly short turnaround time for the employer to provide the agency with whatever it's asking for. It's plan documents, it's SPDs, it's stop loss certificates, non-discrimination testing. There's a demand for a lot of paper that comes along with these audit letters, and typically, if you're lucky as a plan sponsor, the DOL will offer to receive the documents by mail or electronically, and that may avoid them coming on site. And certainly, if they do present that as an option, you generally want to take them up on that and keep them off of your campus. So again, the process typically starts when the agency sends a letter to the plan sponsor. It advises it that it's going to be audited. Typically, if it's a qualified plan audit of a retirement plan, it'll be focused on one plan. If it's a welfare plan audit, then it'll generally be for either one particular health plan, or it could be all benefit options that are sponsored by the employer. We often see for our larger clients, they may tend to have a self-insured plan for the vast majority of their employees, and then other employees in more remote areas, they might give them fully insured plans. And so typically in those situations, the agency will be more interested in looking at the self-insured plan than the other smaller fully insured plans. The letter also advises the employer that the agency will visit them on a certain date to review the plan documentation, and that on-site visit may be obviated if they can provide the information the DOL is looking for ahead of time. And there usually is a fairly short time frame in which to respond. Usually it's no more than a couple of weeks. So on the next slide, the first thing that we always recommend is that whenever you get one of these audit letters, or when your client receives an audit letter, the first thing they should do is engage a risk counsel. The clients will often look to their in-house counsel or their benefit consultant to help them with an audit, and while the brokers certainly are instrumental in assembling the documentation, they should avoid taking the lead role in talking to the DOL, as should the in-house counsel. When we deal with the DOL, we're often very successful in negotiating an extension for the response. We can assist the plan sponsor in assembling responsive materials. We can also do a bit of a desk audit and review them ahead of time for smoking guns. And really the main reason is that your communications with your outside counsel will have the benefit of attorney-client privilege, where your emails to your broker will not. So switching gears now a little bit to what they audit, we're going to start with the plan document requirements, and we can move on to this slide here. And so, just so we're clear on the terms, all health and welfare benefit plans that are governed by ERISA must have a plan document and a summary plan description. They can be separate documents or they can be the same document, but the plan document is really intended to be the formal document that governs the terms of the plan. It's the document that establishes the plan upon corporate resolution, and it describes the eligibility It describes the duties and responsibilities of the participants and the plan sponsor. And the SPD is what is distributed to participants. That is intended to summarize the terms of the plan, and it's supposed to be written in a clear, non-legalese fashion. And the regulations actually state that the SPD must be written in a manner so that it can be understood by the average plan participant. And so it requires the limitation or the elimination of technical jargon and long, complex sentences, and they encourage you to use things like clarifying examples and illustrations, the use of a clear cross-reference, and also a table of contents. Now, even though the plan document is the legal document that governs the terms of the plan, in the event that the terms of the SPD conflict with the terms of the plan document, the courts often defer to the SPD when interpreting participants' rights. This harkens back to contract principles. Generally when a court enforces a contract, it doesn't require proof that the parties actually read or relied upon the particular terms of the contract. And likewise, a court could be persuaded that enforcement of an SPD's terms under a claim for benefits does not show or does not require a showing of reliance. So in other words, a participant doesn't even have to claim that he or she relied on the SPD because the claims for ERISA benefits are contractual in nature. So if the SPD conflicts with the plan document, then the court may read the terms of the quote contract to include the terms of the plan, but as they are superseded and modified by any conflicting language in the SPD. So, when we put these together, plan documents and summary plan descriptions, very often we will do so on a consolidated basis, and the plan document and the SPD will really be consolidated into the same document. And if you look at our wrap document template that we provide for Percential, you'll see that's how we did it. So in terms of this slide here, again, the plan document is going to explain the benefit structure and how the plan operates, and then list certain other information that is required to be provided to participants. The SPD gets sent out automatically, and I'm going to talk about that in a couple of minutes, but the plan document only really must be provided to participants upon request. But from a practical standpoint, when you have fully insured plans, the carrier document essentially is the plan document, and then the question is, does it also qualify as an SPD? And so a lot of employers use the carrier documents not only as the plan document, but as the SPD, and that's part of what the DOL will look at in an audit. They'll look to see whether the carrier document fits all of the SPD requirements. And we're going to talk about that in a couple of minutes. So let's go on to the next slide. So the plan document has to include a bunch of information on the plan name, the plan number, the plan year, the different features that are included in the plan, like is it just medical or is it dental and vision and life insurance and all the other ancillary benefits. It will need to name the fiduciaries under the plan. Typically, that's the plan sponsors, the named fiduciary. In general, a fiduciary is an individual or entity that has discretionary authority or discretionary control with respect to the management of the plan, meaning it can amend the plan. Someone who is simply making recommendations to a plan with regard to maybe calculating benefits or processing claims is still not a fiduciary. The TPA, if they're processing claims, may or may not be a fiduciary. Typically, If they are taking on appeals and they are making final determinations under the plan, then they will be a fiduciary in that respect. In terms of funding policy and procedure, how is the plan funded? Is it self-funded? Is it fully insured? Is it trust involved? Is it minimum premium? So those kinds of things get disclosed there. Another important set of items in any plan document are the plan amendment and termination procedures. You want to make sure that you have those in the plan. Otherwise, if the plan wants to make an amendment, it could find itself in the unenviable position of having to violate ERISA in order to amend or terminate the plan. And that doesn't happen too often. Usually the sponsors do in fact include those provisions in the plan document. Very important is an explanation of how and when payments will be made under the plan, as well as the plan's claims procedures. There's a famous case that illustrates the need for proper claims procedures, and that case is known as the Firestone case. You may have heard of this one. For self-insured plans in particular, where the employer is the one that's going to be on the hook for paying claims, it's extremely important to have pristine claims procedures that comply with ERISA and that the plan administrator follows to the letter. In the event that the participant sues, and this will usually happen over a claim denial, if the plan can show that it followed their claims procedures as they're laid out in the plan document and in compliance with ERISA and the Affordable Care Act, and that the plan sponsor has not acted in a capricious or arbitrary manner with regard to the denial, then when the claim goes to court, the court only reviews whether the company followed the claims procedures, or whether the plan followed the claims procedures, not whether the claim was actually properly denied. And so the Firestone protection provides relief from the participant getting a de novo review in court, meaning that the court, again, will just look at the information available to the plan administrator at the time of the denial and is not going to re-adjudicate the claim as long as Firestone protection applies. So the plan sponsor, plan administrator, really wants to preserve that Firestone protection because de novo review allows new evidence to be brought in, whereas the Firestone protection just limits the court to reviewing the claims procedures and what was available to the administrator at the time, and then they're really just looking to see, was there any arbitrary or capricious behavior? Was there a conflict of interest? If there's no arbitrary or capricious behavior, then the plan administrator's decision should be upheld. So extremely important to have that in there for self-insured plans. Let's go to the next slide. Again, the plan document must be made available to participants for inspection. It must be provided upon request, but it's not something that needs to go out affirmatively. Common issues with retirement plans, the plan document might not be kept on site. This is something we see very often with employers that use prototype plans, where all they have is the adoption agreement, which is essentially an outline of the pertinent terms of the plan, but that's not sufficient from a plan documentation standpoint. Other common issue is that retirement plans don't get touched as frequently as health and welfare plans, and so you can find them where they haven't been updated for certain changes in the law. Most common issues with health and welfare plans are undocumented arrangements, and this is particularly an issue with flexible benefit plans, including health FSAs and dependent care plans, where the employer does not maintain a written flexible benefit plan to include those other features like salary reduction, HSA contributions, health FSAs, and dependent care FSAs. all of those must be part of the written flex plan or cafeteria plan. Likewise, health reimbursement arrangements or employee assistance plans. There's more of a problem with health reimbursement arrangements where employers will cover certain out-of-pocket claims incurred by their plan participants, and they don't maintain the proper documentation for it, and so it's unclear whether they're complying with COBRA properly and HIPAA properly, and so undocumented arrangements are generally part of every audit. And most commonly, I think, for fully insured plans, whether the carrier's document, whether the certificate of coverage, certificate of insurance, policy, whatever they want to call it, whether that document constitutes qualifies as an SPD for insured plans, or if it even qualifies as a plan document. Many times, it's not going to. It's going to be missing certain minor things like the ERISA rights statement or certain information that is known only by the employer and maybe not by the carrier. And then lastly, the other issue is poor documentation of self-insured plans. And another, you could be held liable for penalties if you fail to provide a copy of the plan document within 30 days of a request. Typical penalties are $110 per day. Those are the civil penalties under ERISA. There could potentially be criminal penalties for willful violations. We don't see that very often, certainly not in the welfare plan context, but it's out there and it does happen. Often it'll happen in the context of a MEWA, where if there's an unscrupulous MEWA promoter out there that takes the money and runs, there could still be criminal charges there. Let's go to the next slide. Okay, so moving away from the plan document requirements, I want to talk about SPDs. So as mentioned, the SPD has to describe the plan's rules regarding eligibility and benefits and the participant rights under ERISA. Things like, what's the eligibility? What type of plan is it? Is it insured or is it self-insured? What results in a loss of benefits? If you enroll in ineligible dependent, is that going to maybe cause you to lose your benefits? The plan should disclose the ERISA rights, like the right to examine the Form 5500 and the summary annual report. It should include things like COBRA continuation coverage. And really, the SPD, it constitutes the single most important source of information about a plan for the plan participants. And as long as it's properly updated, that might be through summaries of material modification or material reduction, then it goes a long way toward making your DOL audit a lot easier. And of course, it's helpful to participants to give them the knowledge they need about how to manage their benefits, the circumstances under which benefits will be lost, whom they should contact about questions and other essential matters. In terms of distributing the SPD, a copy of the SPD, it must be provided to each participant. The plan must have demonstrated procedures. You can provide SPDs with the enrollment materials. In general, you have 90 days to get someone an SPD after they become a participant, or if the plan is brand new and they're still developing the SPD, you have 120 days after a plan first becomes effective. In the past, before PPACA, plans could go several years without being amended. And this last rule here on the last bullet provides that an SPD must be provided at least every 5 years if there have been any changes during that 5-year period. So you can use summaries of material modification and reduction, but every 5 years you should give a copy of the SPD. Next page. The SPD has to be provided at least every 10 years if there have been no changes to the plan. That obviously is just not applicable these days in light of healthcare reform. If there is a material reduction in covered services under a group health plan, then you must notify participants within 60 days after the date the plan or the date the change has been adopted by the plan. So this is not an advanced notice requirement. This is ERISA's 60-day requirement that must be followed within 60 days after the plan adopts the change. There's a separate advanced notice requirement under the ACA, which basically provides that if you make a mid-year plan design change and it's not in connection with the renewal, then you must notify participants 60 days in advance of the date the change will be effective if the change affects the content of the plan's summary of benefits and coverage, the SBC. That's that new 8-page or so document that's required to be distributed under the ACA. So again, the 60-day advance notice requirement, it only applies to changes made mid-year and to changes that affect the content of the current SBC. So if the change doesn't affect the content, then the advance notice requirement does not apply. So in terms of the SPDs, common issues is that the information in the SPD may not match what's in the adoption agreement or how the plan is operating. And sometimes we find that all three of these do not match, where the actual operation of the plan is doing one thing with regard to, say, a matching contribution or an employer contribution. The adoption agreement says another thing, and then the SPD says yet a third thing. So you want to make sure, obviously, that your SPDs, adoption agreements, and actual plan operation match. A common issue for the health plan is that the benefit booklets that are provided by the carriers do not qualify as SPD. They might not reflect the actual eligibility requirements imposed by the employer, or they might just be missing some required provisions like WICRA, the claims procedures, RISA rights. And in light of the ACA, we now have the possibility of employers using measurement and stability periods to identify their full-time employees. And if you use these to determine actual eligibility for benefits under the plan, they should also be included in the plan description in the SPD. The carrier documents are typically not going to go into that level of detail. SPDs also need to include assistance for foreign languages or foreign language speakers. The foreign language rules don't require the plan to provide new written materials, but they should provide them with some kind of reasonable opportunity to be informed of their rights under the plan. And that could be a helpline, could be supplementary written materials. They have some flexibility here. I'm not going to go into detail on the foreign language requirements, so we can go to the next slide. But if you have questions on the foreign language rules, we can cover them after the session today. SMMs, summaries of material modification. This is a way to communicate a change to a plan without having to entirely restate and redistribute the SPD. Some employers prefer to just describe the latest changes for the plan year in open enrollment materials or in some other letter or memorandum or other format, rather than baking them into the SPD, and then the only way the participants will know about the change is that they'll have to be provided a new SPD, a new summary plan description. Let's go to the next slide. Summary annual reports. These are also part of every DOL audit. They're kind of an innocuous requirement. After you file the 5500 for certain plans, you need to provide a summary annual report. And this is basically a narrative description of the 5500. So you have until the end of the 7th month after the plan year to file the 5500. You have until the end of the 9th month to send out the summary annual report. You get an automatic extension if you timely complete the Form 5558 and submitted it with the Form 5500. Common issue that we see for health plans is that there's a misconception that summary annual reports are not required. The answer is that if there is a Schedule A or the plan is funded through a trust, then a summary annual report is required. For a typical self-insured plan that is not funded through a trust and does not have an insured aspect to it, then there is no Schedule A required because the company is paying the claims out of their general assets. There are issues that occur with regard to stop loss, depending on whether the stop loss policy is held by the employer or by the plan, or whether there are employee contributions that are attributable to those stop loss policies. In those cases, you may get a Schedule A from the carrier, and in those cases, the stop loss Schedule A generally would be included. We can address questions on that at the end. Okay, so next few minutes I want to spend on ERISA's electronic distribution rules. So ERISA includes a number of notice requirements, as we know. Summary plan descriptions, amendments, summary annual reports, COBRA notices, summaries of benefits and coverage, HIPAA special enrollment rights, WICRA notices, QIMSCOs. All of these notices may be provided electronically if certain requirements are met. Let's go to the next slide. Okay, let's go one more forward. So these are the basics that a plan must comply with in order to qualify for electronic distribution. We're going to run through the basics, and then we'll talk specifically about the types of recipients. There are two different types of recipients that can receive ERISA-required documents electronically. So in terms of the basics, the plan administrator must ensure that the system for furnishing documents results in actual receipt of the transmission. This can be accomplished by using return receipt notices, notices of undelivered email failures. You can conduct periodic reviews or surveys to confirm receipt, but you must take reasonable and appropriate steps to ensure that people are actually getting the SPDs. When you give out these SPDs electronically, they should generally be consistent with how they're formatted when they're printed. Participants will always have the right to request a paper version at no charge. And anytime you are communicating to participants that a new electronic document is available, you have to notify them, and you have to send a little note out and make sure they understand the significance of the document. And that can be pretty brief. It can be something as simple as, we posted new benefit materials for 2015. included are medical, dental, and vision, summary plan descriptions, and summaries of benefits and coverage. You should take a close look at these as you'll need them to understand your benefits. Something as simple as that. So once the basic requirements are met, the ERISA required documents can be disclosed electronically to two separate classes of participants. The first class are people that basically use their employer's electronic information system as an integral part of their job duties. So if you're issued a laptop or a BlackBerry, and you have email access, and you have a computer at your desk, these are folks that automatically consent to electronic delivery of ERISA required documents. So someone like myself, I have a desktop computer at my office. Company provides me with a laptop. I automatically consent to electronic disclosures. They don't need to seek my approval before emailing me all of my ERISA required notices. Now, in specifically, these are people that the folks that automatically consent. These are employees that use the employer's IT and information technology system as an integral part of their job duties. And so the regulations are specific to say that simply setting up a kiosk in a common area of the workplace will not comply with the requirements. That is not someone that only has access to the SPDs through a kiosk is not someone who automatically consents. That person would need to affirmatively consent to receive those ERISA documents electronically. That brings us to our second category of participants, and so these are folks that do not access the employer's information technology system as an integral part of their job duties. So obviously folks like retirees, terminated participants with vested benefits, if you're talking about retiree plans, these individuals must affirmatively consent to receive documents electronically. They have to provide an email address, and then part of their certification will basically be confirming that they have the right software and the right packages to receive those documents, meaning they have access to email, they have access to Microsoft Word or Adobe Acrobat or whatever application you need to review the documents, and that should be part of the consent form. Document retention rules under ERISA. Basic rule is that ERISA required documents should be maintained for 6 years after the date of filing, resolution, or amendment. The materials may be preserved electronically, but they should be in a manner that is that permits easy access and ready retrieval. If you store them off-site, you want to make sure you can get to them within a couple of days. We typically recommend saving things like annual reports, disclosures, board resolutions. Let's go to the next slide, because I think I actually have a list of, so things that should be maintained, the original plan documents should be retained so that you have an inception of the plan since its effective date, or a record of the plan since its date of inception. Participant disclosures, the 5500s, SARs, SPDs should also be maintained for 6 years. Any trust documents, non-discrimination testing results, notices of credible or non-credible coverage also should be maintained, even though those are now defunct under the ACA, and I'll talk about those in a second or two. Let's go to the next slide. We often hear from clients when they're in the throes of a DOL audit, and the DOL is asking for materials going back 6 years, 7 years. The common misconception is that the agencies only look back 3 years. That's not necessarily true. Typically, the IRS, when they audit, they tend to audit the last 3 open tax years, but that rule doesn't apply in cases of fraud or misrepresentation. And from an ERISA standpoint, the DOL will often look back 6 years or even more, particularly in the case of a grandfathered plan. Not 6 years into the ACA yet, but when we get to the checklist in a couple of minutes as to what the DOL looks for, they're looking for all of the records for the plan. For any plans that are grandfathered, they want to see all the records since or going back as far as 2010. Let's go to the next slide. So everybody's favorite topic, Form 5500. The biggest part here is that they must be timely filed. They must be filed by the end of the 7th month after the close of the plan year. That is, by July 31st for calendar year ends. All retirement plans have a 5500 requirement. Large plans have an audit requirement. Small employers may not have an audit requirement under their retirement plan. Let's go to the next slide. One thing to note about 5500s is that I think starting back in 2008, maybe it was 2009, all 5500s need to be filed electronically. So over the last few years, those of you that file 5500s should have been doing that online using the EFAST system, which is used by the DOL and the IRS in the PBGC, which is the Pension Benefit Guarantee Corporation. 5500s are always a part of every DOL audit. Even health flexible spending accounts, they have a 5500 requirement. If you use a wrap document, they may not be disclosed separately, but all ERISA covered plans are required to file 5500. And that includes things like the LTD plans, AD&D, group term life. Another common misconception is that the 5500 rules don't apply to nonprofit entities. There is no blanket exemption for nonprofits or tax-exempt entities. The 5500 requirement is triggered based on whether there are 100 employees or more participating on the first day of the plan year. If you don't have 100 employees participating in the plan on the first day of the plan year, then for a health or welfare plan, you don't have a 5500 requirement in general. Premium-only plans, Section 125 plans, flex plans are not required to file a 5500. Dependent care FSAs also are typically not ERISA plans as long as the employer is not contributing to the dependent care FSA. Let's see. So we do often see from time to time that plans and employers are delinquent with their 5500 requirements or their 5500 filings. Penalties for late filers and non-filers can be significant. And once the IRS has notified an employer of its intent to audit, then these are the types of penalties that can apply. If you've not been filing 5500s and you have more than 100 employees in your plans, then you should strongly consider the Delinquent Filer Voluntary Compliance Program, the DFVCP. this is, again, it's available only prior to audit, and it greatly reduces the potential penalties for failure to file 5500s. The general rule is that when you file under the DFVCP, the penalty is only $10 per day, up to a maximum of $750 for small plans. For large plans that have 100 or more participants, the penalty is $10 per day to a maximum of $2,000. And if you have more than one plan with respect to which you are delinquent, then the maximum penalty is $4,000 per plan. But there's an approach that plan sponsors can take, and that is to use a wrap document, and you can consolidate your plans into one plan number. And so at the end of the day, even if you've had several years of delinquent filings, you may be able to remedy that for a one-time combined penalty of $4,000 rather than $2,000 for each plan. And if you have 10 plans that are late, then obviously, it's definitely going to be a better deal to do the wrap document approach. And you should work directly with counsel when you're doing that so they can review all the facts and circumstances. HIPAA portability, just remember that for HIPAA failures, COBRA failures, ERISA failures, ACA failures, a lot of these are self-reporting failures. You report them on Form 8928. If you feel that you do have a reportable failure, you should work directly with counsel, and we can advise you on how to complete those forms or whether you should complete those forms. We have seen an increased audit activity on HIPAA portability rules. As you may or may not know, the certificates of creditable coverage, those are now defunct and they no longer apply starting in 2015. These are not the Part D notices. Those are something different. These certificates of creditable coverage are what you get when you terminate participation in a group health plan. You get a copy of your certificate of creditable coverage, and in the past it was used to inform the next plan whether you should have or be subject to a pre-existing condition exclusion. Now that the ACA has eliminated them, there's no more need for certificates of creditable coverage, and they have been formally amended out of existence. You want to ensure that you are providing notices of special enrollment and that the plan does not discriminate based on health factors. The HIPAA privacy rules, we now have new final HIPAA privacy rules that were finalized back in January of 2013. These have new, fairly significant penalty provisions. In the past, when HIPAA was first passed into law, the penalties were viewed as fairly limited. The maximum penalty was $25,000. But now, under the High-Tech Act and the Omnibus Rule, the penalties can be up to $1.5 million per year. The High-Tech Act also allows the state AG, the Attorney General, to pursue civil charges on behalf of victims. And so, there have been suits, particularly in New England. There was one over the loss of a hard drive last summer that contained data for about 500,000 people, and the AG in that state, it happened to be in Connecticut, that AG sued under High-Tech and was able to recover some penalties for the data breach. The big thing to remember for HIPAA is just you want to make sure that you have your breach and encryption protocols updated to reflect the High-Tech Act. Cafeteria plans, plan documentation issues are a big issue. We do often find that plan sponsors do not have written cafeteria plans, or they can't find them, or they haven't been updated in years. If you can't find your cafeteria plan, you should talk to your benefit broker at Percential, and they can help. And again, the cafeteria plan audits are part of any IRS audit typically. Recent audits of cafeteria plans have found that they don't have the signed plan document, and that the plan has not been updated in many instances. Word about mental health parity. Final mental health parity regulations were released or were effective last year, plan years beginning on or after July 1st of 2014. We've seen a huge focus on non-quantitative treatment limitations under audits. In my experience, in the last few audits that we've assisted clients with, the major issues have been with regard to mental health parity. So there are kind of two categories of limitations under mental health parity. There are financial requirements that are quantitative treatment limitations, where you're just backing off payments, changing the payment structure for mental health and substance use disorder services. And then there are the non-quantitative treatment limitations, which are limitations that are not expressed numerically. And so things like formulary design, standards for provider admission into a network, methods for determining usual, customary, and reasonable charges, exclusions based on failure to complete a course of treatment. These are all illustrative non-quantitative treatment limitations. Two new ones have been added to the list. In particular, the second one here, restrictions based on geographic location, facility type, and provider specialty are now questionable non-quantitative treatment limitations that must apply equally to medical and surgical benefits as they apply to mental health benefits. And so if you're excluding coverage for residential treatment facilities, you could have an issue there. And these are often huge cost drivers for plans, and so we do see plans that try to take or have provisions that limit access to residential treatment centers or exclude certain types of coverage within the continuity of care as a whole that they don't do for medical plans, and these are all things that the DOL is looking for. HRA's health risk assessments, they're really not much of an audit issue. Just be aware, though, that, and we've talked about this a number of times before, that while the Department of Labor says that you can use HRAs as a gateway to eligibility, meaning that you can require employees to fill out an HRA to get into the plan, the EEOC disagrees and claims that that is a per se violation of the ADA. The EEOC, as you know, has been on the warpath in the last 6 months or so. No fewer than 3 lawsuits they have started, and so in 2015 we'll see how those lawsuits are going to flesh out and whether the EEOC is going to engage in some more formal rulemaking, and so we can have some rules to rely on and understand what works with regard to mandatory health risk assessments. Still worried about wellness plans. They also are typically part of audits. There are new rules for wellness plans that were effective in 2014. They increased the maximum reward and penalty, but they also changed how the rules apply in large part. When you have wellness programs that are health contingent, that condition a reward upon satisfying the standard that is related to a health factor like being a non-smoker, you must provide a reasonable alternative to any individual who does not satisfy that initial standard. So it's not like an employee has to say, it's unreasonably difficult for me to quit smoking, or it's medically inadvisable for me to quit smoking. All that has to happen is they fail to comply with that initial standard, and they automatically will get the alternative, which will be something like completing a smoking cessation program. So we strongly recommend that employers with wellness programs have been reviewed by Benefits Counsel prior to implementation. The next couple of slides I'm going to move through relatively quickly, and those are the new issues created by the Affordable Care Act. They are engaging in serious audits of grandfathered plans. They want to see all of the documentation going all the way back to March 23rd of 2010, and anything else that's required to verify the grandfathered status of the plan. So be prepared to do that if you're grandfathered. On the next slide, for all group health plans, we're seeing all of these new audit items under PPACA. Documents relating to emergency services parity, the preventive care rules, the internal claims and appeals procedures. That's a big one. You want to make sure you're using the updated notices of adverse benefit determination. You've contracted with third-party external reviewers if you're self-insured. Let's go to the next one. And then the other mandates and market reforms, like rules regarding rescissions and lifetime limits and annual limits. And we've even seen the DOL ask for disclosures relating to the choice of primary care physician. Most plans that are PPOs, POSs, anything but an HMO essentially, do not require participants to designate a primary care physician. In an HMO plan, they typically do require designation of a primary care physician, and in that event, the plan must inform participants in women and children that they can use a gynecologist for a women's PCP, a pediatrician for a child's PCP. And the interesting thing, though, is that this only applies to plans that require designation of a primary care physician, but the DOL is asking for that statement for all plans. So we include that in our Form wrap document, even if it's not applicable to the plan, just because we're starting to see the DOL ask for it. And then lastly, just another word about the whistleblower rules, because we're starting to get more questions on that. Employees have protections under the ACA. You cannot retaliate against an employee who receives a premium credit for exchange coverage, or any other employee who is seeking to assert his or her rights under the ACA. If you have an employee complaining that they think that certain benefits should be included under the preventive care requirements, even if they're wrong, their activity is protected. So you just want to make sure that your managers and HR folks are not retaliating against those employees. Again, just good to inform managers about these whistleblower protections. We're already at the top of the hour. I think this is my last slide anyway, so let me conclude here. I can stay on for a few more minutes if folks want to ask questions. I'm going to check to see if any have come in to me.
Yeah, I have a couple here. Stacey, as well.
Yeah, I don't see any on my end, so Chris, if you want to go ahead and read them, I'll address them.
This one here is EAPs, 5,500 forms and SPDs. Can you explain that an EAP may need to file a 5,500 form?
Okay, you were cutting out a bit, but I think the question is on EAPs, and then when do you need to file a 5,500 and have an SPD? So,
that's correct.
Okay, so basically, most EAPs are welfare benefit plans under ERISA. If the EAP is a referral-only program, doesn't provide any counseling sessions whatsoever, then it's not going to be considered a group health plan. It provides any counseling sessions at all, then it's going to be subject to ERISA, it's going to need an SPD, and it's going to need a 5,500 filing. Now, a lot of EAPs are embedded in other products, like a long-term disability plan. So in that sense, you may not have a separate SPD or a separate 5,500. You may be relying on documentation within the long-term disability plan. But if you're as a company, if you have a separate separate EAP plan, and it provides any counseling at all, then it's going to be a group health plan. It needs to have a 5,500 if there's over 100 employees participating, and it needs to have an SPD.
Okay, is there a resource that provides an easy sample to follow and populate with our information that meets all the ERISA requirements for both SPD and plan document?
Yeah, I mean, we offer through Percential to Percential members a model plan document and summary plan description. And so what that is used for, how it works, is that it wraps around whatever carrier documentation that you are supplied with. And so maybe the carriers, might give you a benefit summary or a benefit booklet. It has most, but not all, of the ERISA required information. The wrap document steps in and supplements the carrier document to make it a full ERISA compliant plan document and summary plan description. We offer that for free to Percential members, I believe. I think so. Sorry if I misspoke on that. But we do offer it to Percential members. We note that it is a model. You should have it reviewed by counsel because it is a legal document that governs the terms of your plan. But we are happy to engage with clients and prepare that document for them.
Okay, and who is responsible for preparing SARs?
Well, the company is, the employer is, but if you use a vendor to prepare the 5,500, the SAR would very likely be part of the services that the vendor is providing. But ultimately, it's on the employer as the plan sponsor.
Okay, a question on electronic disclosures. You say you have automatically consented if the employer has provided the technology. Does this apply to other electronic documents not related to ERISA, such as pay statements?
I do not know the rules for those off the top of my head. If you can, give like a W-2 out or a pay statement out automatically to those folks. I know I haven't gotten one in the mail in years, and I don't remember I don't remember affirmatively consenting, but and that's something we need to look into separately, and advise an employer directly on it if they have questions on that. We're happy to dig into that further.
Okay. If an employer has had a look-back measurement method policy drafted to include in its handbook, could it incorporate the policy into the SPD by reference, or should the entire policy be repeated in the SPD?
No, it's certainly possible and reasonable to include it by reference. in our wrap document, we incorporate all of the carrier documents by reference. So that is a very common approach. I don't see a need to repeat the whole thing in the SPD as long as the right people are getting the employee handbook and it's clear. Then it can certainly be incorporated by reference.
Okay, and also regarding Form 5500 filing requirements, do you have any thoughts on whether telemedicine programs offered by employers are subject to ERISA?
That's a loaded question. In full disclosure, we represent several telemedicine vendors and some of the larger ones. Whether a plan is subject to ERISA is something that an employer should determine with the assistance of counsel. The easiest approach is to consider it part of the group health plan and then part of, and therefore subject to ERISA, is the basic, most simple method. I think it's certainly a consideration, something you need to think through, that if you were to offer telemedicine on a standalone basis, separate from any group health plan, and say that was the only benefit you offered at all, would that rise to the level of a group health plan? It is certainly possible. I mean, you're talking to a doctor, they're providing you a prescription. That's something you should talk to an ERISA attorney about. But all things being equal, I would recommend considering it to be part of the group health plan, and therefore you piggyback on the group health plan's documentation 5500, and so there shouldn't really be any additional separate filing requirements for the telemedicine program.
Okay, the next question. We are not required to file Form 5500 if we don't have 100 or more employees participating in our health plan. Is this correct? I just want to confirm.
That's right. If there's not 100 or more employees participating on the first day of the plan year, there's not a 5500 requirement. Now, just to be clear though, if you've been filing a 5500 and you dip down below 100, you have to file a final 5500 or make another notation. There are codes to use when you don't expect to file a 5500 in the future year because the plan is now small. But that's kind of getting to the minutia. But yeah, the general rule is that for health and welfare plans that are unfunded or fully insured, there's no trust, there's no 5500 requirement until you have 100 employees participating.
All right, and the last question, does the EAP, which has counseling services, have to follow all the ACA group health requirements, no limit, etc.? If a company has an EAP that is for five counseling sessions, then it refers, how do they meet those requirements if they are considered a group health plan?
Yeah, great question. I'm glad that they asked that, and I should have clarified. EAPs, while they are group health plans, are HIPAA-accepted group health plans. They are just like dental and vision for that purpose. And the ACA does not apply to dental and vision plans, so none of the insurance mandates and the market reforms, none of that stuff, the annual limits, the dependent age, that does not apply to EAPs because they are HIPAA accepted.
Okay, great. Well, thank you very much, Stacy. That appears to be the question for the day. So I appreciate you presenting today, and I appreciate everyone for joining us today. To the CRC, if you do have questions, feel free to reach back to your potential broker partner. Thanks a lot, everyone, for joining us, and have a great day.
Thanks, everyone. Take care.